matter of Brunner versus Robbins. Present in the courtroom is Mr. Zeski representing the plaintiffs. Also present in the courtroom is Mr. Alvarez representing defendant Robbins and, I'm sorry.
That's right, Your Honor. Mr. Mike Reed, Joshua Mike.
Mr. Mike Reed. And you are representing?
Mr. Robbins as well, Your Honor.
Is Mr. Ortman represented?
By
You're representing him also. This is a motion to stay proceedings brought by Mr. Alvarez, correct?
That's correct, Your Honor.
Mr. Zessin, did you have some?
Well, I had a motion too.
I'm sorry. And you have a motion also?
For contempt, enforcement of order, sanctions, and reimbursement of fees. Filed on October 11, 2013, which originally initiated these proceedings.
It appears that we're in position to hear your petition first. Mr. Zessin, correct?
I would think so, Your Honor. Thank you. When we were in court last on October 17th, I made my presentation in support of my motion seeking an order of contempt, enforcement of various orders that had been entered with the court as it related to the construction of the swale and for a reimbursement of fees. The court is aware of the background of this case in the sense that you have ordered that Mr. Robbins created a nuisance. You have ordered, pursuant to a stipulation, that there would be a specific method by which the nuisance would be abated. You ordered that Mr. Bexford from Allegan Engineering would go to the site, stake the swale in accordance with his survey of August 9th, 2012, that a licensed excavator designated by the court as RP Septic and Excavating, Inc. would go to the site, perform the excavation services consistent with the swale marked by Mr. Bexford, and that at the completion of construction, Mr. Bexford would go back and approve that swale. In spite of the fact that you made some very clear and concise orders with respect to the abatement of the nuisance, Mr. Robbins has decided that he wanted to do something different. And what he decided to do was to hire his own excavator, or Mr. Ortman did, to go out on the property and attempt to abate the nuisance by constructing a swale. That was done sometime at the week of August 26, 2013, right after you had ordered a denial or denied their motion for summary disposition and other relief that they were requesting. Without advising the court, without advising me or anyone else, they went out and undertook this unilateral conduct. Where we got to then was on August 11th or 10th, I was notified by Mr. Alvarez that he would not be permitting Mr. Bexford on the property to stake the property, would not be permitting RP Excavating to go onto the property to construct the swale as required by the survey study, and he would not let Mr. Bexford go on the property to even look at the work that had been done. So we called the court. Court scheduled, required me to have Mr. Bexford submit additional information concerning why the existing, or why the swale that they attempted to construct, even though it was done in violation of the court, or why it didn't comply with the survey. Mr. Bexford is here today. He's been to the site. You ordered him to go back onto the site and to determine what is about this, it is about the swale that does not comply with his engineering study, and therefore the order of this court. He is here today. He's prepared to testify. He's made drawings. He will show you that there is about a 5¼ inch hump in the middle of the swale that's been constructed, which exists over about 100 feet in length by 10 or 12 feet in width. And he will explain that there's a very simple solution to this problem, simply by allowing him to stake where the problem exists, having RP Excavation go out there, excavate further so that there is a continued positive flow in the swale, so that the water can continue to be evacuated from the property consistent with historical levels, historical meaning pre-pond digging by Mr. Robbins, and that the water can evacuate itself out through the swale, and that would be compliance, in his opinion, with his recommended solution to abating the nuisance. So we're at a point now where we can get this done relatively easily. He can testify what needs to be done. He's prepared to have this done before the end of the year. There's obviously continuing problems out there as water continues to build because it can't be evacuated. This is not a situation where 3 or 4 hours of further excavation can't solve the problem. And Mr. Bexford is here prepared to testify. In addition, you have ordered reimbursement of about $6,000 worth of attorney fees, costs, and his expense, and Mr. Bexford's expenses. Those fees continue to accrue starting in October, in the first part of October, when I was notified that Mr. Robbins decided that he was not going to abide by the court order, and it required Mr. Bexford to go out to the site 2 or 3 more times. It required me to come to court 2 more times. It required me to file additional pleadings. It required me to file other pleadings that related to a new motion that has been now filed by them with respect to their appeal. So we have this continuing problem. Not only are the $6,000 that was supposed to be paid in order to be paid immediately, those are not paid, but we have this continuing accumulation of fees and costs caused by Mr. Robbins' defiance of the court's order. And we're asking that those additional fees be ordered to be paid in addition to the $6,000 that the court's already ordered. Does the court have any questions?
No, I don't. I believe you've indicated that Mr. Beckford's here to testify.
He is. And I did file a response to, and I don't know if you want me to argue the motion, if you want to let them argue their motion for stay of proceedings, and then let me respond to it. But this is my argument on my motion. Mr. Beckford's here to testify.
I understand.
Thank you.
Well, I'm going to call Mr. Beckford unless you wish to make some statement at this time, or do you want to wait?
Your Honor, we would object to Mr. Beckford's testimony at this point. We were under the impression that we had only an hour to present testimony. We did have Allegan Engineering that was scheduled to come and testify today, but due to some scheduling error at the court, we understood that our 2.5 hours that we were promised was cut down to an hour. We found this out actually just yesterday, I believe.
Who promised you 2.5 hours?
The court did when it said it. It was from 2:30 to 4:30. So we believe we had 2 hours to present testimony on these 2 motions.
I'll have to go back and look at that. I don't recall that.
And then yesterday when we called to confirm the hearing, it wasn't even on the docket for today, Your Honor, and some quick work, I believe, by the court was able to put us back on the docket. But we are not prepared with testimony as we had anticipated because we only have 1 hour to work with.
Did someone tell you not to bring in witnesses?
Yeah, we did speak with the court's clerk, I believe, and indicated that perhaps it was not going to be an evidentiary hearing because of the fact that it was only an hour. that we were going to have to work on these two motions.
Did someone tell you not to bring in witnesses?
Your Honor, I can speak to that more specifically. I spoke with Avery. He obviously didn't tell me not to bring witnesses. I tried to sound out whether or not this is going to be an evidentiary hearing was the thing I wanted to determine. And it wasn't set as an evidentiary hearing. That was the principal message that I got from the clerk. And we are more than happy to have an evidentiary hearing, Your Honor, on these issues, but we didn't think with an hour. I mean, there's all kinds of evidence that's relevant to this. And if that's going to be the way of it, we would intend to call probably 5, 6 witnesses on all these issues that we've got at bar.
Well, how long are we going to drag this out?
Well, Your Honor, we would...
The intent of the court was to get something accomplished today, and what you're telling me is you're not going to get that accomplished because you're blaming the court for that.
No, Your Honor. What we're
That's
saying is...
That's exactly what you're telling me.
No,
this is getting
please.
ridiculous.
Well, allow me to clarify. What I'm saying is we are prepared to address today the merits of the motions that are on the record at this time, and we anticipate that the court could make a full decision based on the merits of these motions. If there's going to be a battle of the experts, we are more than happy to engage in that battle, Your Honor, but we would like some notice that that's what's going to happen. Because obviously when you talk about expert testimony going both ways, it's a complicated affair, and it certainly can't be dealt with in an hour.
Here's the issue. We can do this without witnesses. I'm going to tell you that I'm going to abide by the previous court order. The previous court order is that this is supposed to be conducted pursuant to Mr. Becksford's belief of what should happen. And that's what the court's going to go rely on its previous court orders. And that's what the court's going to do in that case. And then I don't need to call Mr. Becksford because Mr. Becksford is saying it's not done.
Fair enough, Your Honor. And Mr. Becksford has obviously submitted written evidence to that effect before the court, which presumably should be sufficient for our purposes today. If all we're doing is addressing these motions.
I don't have any written evidence. There's no evidence submitted.
We actually submitted it, Your Honor, as exhibits with our motion to stay.
That's not evidence. That's a pleading
Okay.
that's been submitted to the court. It certainly doesn't rise to the level of evidence when it's submitted as a pleading.
I'm sorry, Your Honor. You're of course right.
Well, Mr. Zesson, we'll have argument from Mr. Alvarez and Mr. Rickred, so you can
I would just, okay. I do have Mr. Becksford here prepared to testify.
As I had always planned to do.
I understand that.
Your Honor, a couple of things. With regard to the basis of this entire process, it's based upon a report that was produced by Latitude Engineering. We have, as we've mentioned a couple of times already, have contracted another engineering firm to review that report and have found some serious discrepancies in that report, which is the basis of the swale, the dimensions, everything that's been discussed up until today. For example, there's a 100-foot difference between the height of the barn and the level of the property owned by Mr. Ortman, which creates a number of issues according to the engineers that have reviewed it. We also have the issue of it was not Mr. Robbins that constructed the swale, it was Mr. Ortman. I understand that Your Honor had issued an order with regard to Mr. Robbins and a specific process which was to take place with regard to the construction of that swale, but Mr. Robbins had nothing to do with the construction of the swale, which is now in question. We had that swale, which was constructed by Mr. Ortman, reviewed by Holland Engineering. They provided the court, as we did back on October 9th, we provided the court with a copy of their certification of the swale. Now, I understand that Mr. Becksford has had some issues with it when he went out to review it after our discussion on the phone with the court, but again, given the discrepancies in the original report, given the fact that we have now discovered that there are discrepancies even with the elevations that were used to produce that original report, and even now, we just believe that there has to be more work done on this case to determine what exactly the elevations really are and what is actually going to produce the proper result for both parties. We also believe, Your Honor, that the flooding that's being caused is not a result of any piling up of 2,000 square yards of dirt, and I understand that we have covered this a couple of times, and there is an order back from October 15th, but we believe that it merits further discovery. We still have the litigation between Ortman and Brunger, which has now been consolidated with this case, which is going to deal with that. That case is going to be moving forward. There is a berm on Mr. Bunger's property, which was not there before, which raises his property clearly about 2 to 3 feet, which also interferes with the flow of the water. And we believe that needs to be addressed. And that berm, as a matter of fact, was not addressed, was not cited, was not raised as an issue in the report prepared by Latitude Engineering as well. And that obviously affects the flow of the water onto both properties. As further evidence, Your Honor, at least as further suggestion as to what is really happening here, Your Honor, in the last couple of weeks that there's been rain, there's been no flooding, as has been described by Mr. Bunger on either property. There has been no substantial flooding as was described or as was depicted by Mr. Bunger from April of last year when we had the torrential rains that even flooded Grand Rapids. So at the very least, this swale that's been constructed by Mr. Ortman is, at least for now, is dealing with the problem. And there's no urgency in having another excavation company come on to Mr. Ortman's property, who is not a party to this case, and begin excavation. There is no risk of flooding or further damage to Mr. Bunger's property, and this will allow the parties to further resolve this issue with better and more accurate reports as to what the elevation levels are, as to what exactly, where exactly the natural flow of the water is, as to how the berm actually interacts with the flow of the water, which was not raised in Latitude Engineering's report back last year. And we feel that at the very least, Your Honor, Mr. Robbins should not be held in contempt because, again, it was not him who constructed that swale. It was not he who had the swale constructed, had the trees cut down, and did not defy this court's order. It is not his property. Any questions from the Honor?
How do you ignore the fact that he entered into an agreement on how to resolve the problem of water on the plaintiff's property, entered into that agreement, agreed to do something, agreed to a very complicated stipulation, and now he's going to just say, oh, I'm sorry, I couldn't have done that, it wasn't my property. It's pretty clear he had control of that property from the fact that he, in fact, entered into this agreement. You want to just skip over that part, Mr. Alvarez. That's a pretty important part for the court. And it's also been told to me several times in this courtroom that Mr. Ortman has been in the courtroom at every hearing. And yet Mr. Ortman never spoke up to say, oh, no, he doesn't own that property, it's mine. Now, that's concerning to the court. And I'm not going to play a game of, oh, my gosh, you know what, I didn't know what was going on. The signed agreement, signed by Mr. Robbins, Mr. Ortman's in the courtroom at all the hearings. I'm not going to just ignore an agreement that people have reached at this point in time. You want to just skip over that piece. That was an agreement. That wasn't something the court came to a decision on after hearing evidence put on the record. It was an agreement between the parties that was thorough and signed.
That is correct, Your Honor. And had that agreement been followed also by Mr. Bexford in the very beginning, we wouldn't be here, Your Honor. We have plenty of evidence that we are prepared to present with regard to the fact that for 8 months there was no issue with the ditch that was constructed at the time per Mr. Bexford supervision and approval.
We had an evidentiary hearing on that already. We already had an evidentiary hearing on that. Evidence has already been presented. We had testimony both from Mr. Robbins and Mr. Bexford at that hearing, as I recall. I don't recall who the other witnesses are right at this moment. And that's when Mr. Robbins was initially held in contempt of court for not following the court order. And the court made some very specific orders as a result of that, and they still weren't followed.
I understand, Your Honor. What I'm saying is that from the very beginning of this case, Your Honor, it should have been handled very differently. Now, that Mr. Robbins entered into this agreement believing that that agreement would short-circuit the ongoing very costly litigation that was surely to ensue, unfortunately, which has now ensued, is something that we can't change. He was
You could
under the
change it.
impression
You could comply with the original agreement like the court ordered.
he cannot comply with the court order, Your Honor, because it's not his property. And that issue was not raised either by the plaintiff, who had the obligation to do their own due diligence in ensuring who the owner of the property was.
The law says that whoever controls or owns the property. The law is pretty clear about that. The case law is clear on that if you control the property and act as if you have control of the property, which Mr. Robbins obviously did by signing that agreement, he's just as obligated. Mr. Ortman can sue Mr. Robbins all he wants, but since you represent both of them, that makes that pretty difficult, doesn't it?
Your Honor, the fact
but
that...
Mr. Ortman can take the action against Mr. Robbins. I think Mr. Berger is not held to a standard of having to determine who an owner of a property is when there's obviously someone who's living on the place, signing agreements and acting as if they have control of the property.
Your Honor, the fact remains that it was an agreement that was entered into to appease judicial economy.
Oh, wait a minute. No, the judge did not ask for this. The parties offered it. It has nothing to do with judicial economy. This court affords anyone who wants their day in court to have it. Don't bring that line to me. That's completely uncalled for. This court did not encourage a settlement. This court did not even know there was a settlement going on. It still was presented to the court. It has nothing to do with judicial economy.
Your Honor, as I understand it, it was an agreement that was reached to avoid further litigation in this case.
For the parties, not for the court.
Correct, for the parties then. The problem remains, Your Honor, that Mr. Robbins entered into this agreement when he was not able to, was not legally able to. And now the court is ordering him to complete a legal impossibility. He cannot comply with the court order.
Because he no longer has control of the property?
Because he'd never had control of the property.
He did have control. He signed an agreement, saves control. He lives there. He moved the property to begin with. He moved the dirt.
He did not move the dirt, Your Honor.
Okay. All right.
As far as we understand, Your Honor, it was Mr. Ortman who constructed the pond, who had the construction company come out, the excavators. It was not Mr. Robbins. Mr. Robbins does live on that property, but he does not control it, and he did not control it at that time.
Why did he sign an agreement? Because
he's the one that was being sued. At the advice of counsel at the time, they believed that was the quickest way to resolve this issue. And again, since it was simply the construction of what he believed a 12-foot strip of a ditch. I understand it's a swale, but as far as they understood, it was just a 12-foot strip that was going to have to be dug to alleviate the flooding. They felt that was the easiest way to resolve it without avoiding further costs. As a matter of fact, Your Honor, they even left the issue of attorney fees for the district court for what reason I'm not even clear yet. So it wasn't like this agreement that was entered into was done as thoroughly as it should have been, given the discrepancies in the report, number one, and number two, just the issues of ferreting out who exactly was the property owner. The complaint itself, Your Honor, says that Mr. Robbins is the property owner. That should have at least been addressed in the settlement that was put on the record, so that it would have been clear. Now, I understand, neither party raised that issue.
Neither party.
Correct. But it's an issue that's out there now.
And you want to hold the plaintiff responsible for that and not your client.
Your Honor, the plaintiffs have the burden of proof, Your Honor. They've always had the burden. They're the ones. But they also had the burden of
Not when you enter into an agreement, you don't have a burden of proof. What burden of proof is there in entering into an agreement?
What I'm saying, Your Honor, is that at that point, they had the burden of ensuring that the allegations they were making were as true and accurate as they could. And
they did that. They addressed it by the person who said they could control the property. And Mr. Robbins signed an agreement as if he controlled the property. Now, if he wants to, make that claim that he didn't have the right to sign that agreement, that's a lawsuit with Mr. Ortman in this court's opinion. What's the issue in regards to the flooding, Mr. Zessin?
Flooding continues. We've got pictures today of the property continuing to flood because the swale isn't constructed properly. That would be consistent with what Mr. Bexford would testify to. That would be consistent with the pictures that he has, Mr. Brunger has, of his property today that has large pools of water backing up because the natural flow of water, which is in a southwesterly direction, which we've already established, has been obstructed by the construction of the pond and piling of dirt. Absent the swale being dug properly, the water can't evacuate. So we have continuing flooding. We have Mr. Brunger, who was at the property today, with pictures to show the court what happens with water in a rainstorm with the swale improperly constructed. And it would be consistent with what Mr. Wexford would say, this is what's going to happen because the swale is not constructed properly.
Have you been at the property today, Mr. Alvarez?
I have not been at the property today, Your Honor, but I have been in these last couple of weeks when we have had also substantial rain. And I can assure you, Your Honor, that from my perspective, the pond that Mr. Brunger has on his property is one of the main sources of problems as well. It has no relief for its overflow. And that itself has caused pooling on the pond and backs up into his property. We have
told
witnessed...
me there was no flooding. Did you look at Mr. Sesson's pictures today?
I have not looked at Mr.
Why don't you
Sesson.
do that and see if the two of you can at least agree on whether there's flooding there or not?
And, Your Honor, we would also point out, Your Honor, that we do, if we had been given the opportunity to present evidence, we would show that even the majority of the neighborhood would attest to the fact that there has been flooding on both properties historically, going back 20 years. That Mr. Brunger's barn, the one that's on the main side of where these allegations have been made, has actually flooded previously.
Why are we relitigating this issue? If we decided in October of 2012 that there's a nuisance and that there's an abatement process that the parties have agreed to undergo, why aren't we just enforcing the order that says this is how the abatement's going to, this is how the nuisance is going to be abated?
Because Mr. Ortman is the property owner and he also has rights on his property.
You want to look at the picture?
Sure. And what am I looking at here? This is
That's flooding on my property that stops at Mr. Robbins' property because of the work that he's done there. And it's going to continue until it's fixed. It's a simple fix.
And again, Your Honor, we would also point out, again, reiterate, that there is a 3-foot berm that was constructed along the property line, along the same area where this supposed 2,000 square yards of dirt was piled up. That is also a cause of any kind of flooding that may have occurred on either property.
Except Mr. Bexford said, this is the way we're going to abate the nuisance. We have a survey. Here's my recommendation. The recommendation was presented to your clients and your client's counsel, and your client's counsel and your client said, okay, that looks good to me. Let's go ahead and fix the problem by digging a swale that he recommends.
Had they known that there were discrepancies in the report, they would not more than likely have accepted that kind of recommendation.
That means you
Okay,
want to relitigate.
I don't think this is an appropriate forum for the two of you. If you two want to argue among yourselves outside the courtroom, that's fine, but that's not how this hearing is going to be conducted. Anything further, Mr. Alvarez?
Nothing further.
Are you making further argument?
Yes, Your Honor, we'd like to,
Well, it's not that much.
oh, I'm sorry, Your Honor, are we not to the point where we're arguing the motion for the stay?
No.
Okay, forgive me, Your Honor.
I believe that pursuant to the court's previous orders, that Mr. Robbins is still in violation of the court's order. There's been nothing different, and it still hasn't complied. There's an actual averment by defense that he has not complied with the court's orders. It's fairly clear. There's absolutely no dispute about that. He just doesn't believe he should have to comply with the court orders because he doesn't believe the court order is correct in enforcing an agreement. In regards to any sanctions and reimbursement of fees, the court does not have before it a complete breakdown of the fees that Mr. Zessin is requesting. He's just indicated he has more fees to request. And I don't believe the court's in a position to specifically order those fees. Obviously, the court can order sanctions in regards to the contempt issue. We've already done that. It hasn't worked all that well. But there's no doubt in the court's mind that Mr. Robbins continues to be in contempt of court. And although you have a bill of costs attached, it doesn't delineate specifically to the court regarding the attorney fees and how the attorney fees. It says Exhibit 1 to the affidavit, but I don't have that exhibit. I'm looking for it in my file. Maybe it's been misplaced in the file, but I don't have a delineation of the fees in my file.
Are you talking about the ones that have already been ordered? Because those haven't been paid either.
No, I understand. They were the part of your motion for today.
For today, right. I assumed that I was going to have to bring a motion for a tax bill of cost based upon whatever your ruling is today and whatever way I have to do forward. So I'm assuming that you're going to tell me to bring another motion like I brought before that says, tell me, break down the cost, break down the fees, and then I'll make a decision.
And then I'll break down in regards to the
engineering costs.
Well, also your per hour fee compared to the community as far as.
That was already done, but I'll do it again.
Was that already done?
That was already done.
I can't find it in the file. I'm sorry.
Okay. You've already approved.
So you may do that.
Okay.
Court order remains that this process has to be completed. However, it's my understanding that the motion to stay is something that the defense wishes to raise at this time. Go ahead.
Yeah, and are there sanctions for the contempt that I can put in the order?
At this time, no, I'm not ordering any sanctions. Financially, this is getting out of control as it is, and he hasn't paid. So the sanctions will go to the court. The court doesn't want the sanctions. The court wants the work done.
Okay.
So that's different than attorney fees.
Yeah, right. Okay, so
I'm willing to order the attorney fees. I'm not willing to I think we're adding up enough money already. And I understand that you would like that, but I'm not willing to do that. I want those fees paid, and at this point we're going to start having to do some type of enforcement of that through a percentage, some type of interest or whatever on those fees. I'm not sure. The court would have to look at that in regards to the situation.
Can we garnish income or something to?
Well, I think we still have to get through the process. Oh, for the past fees,
right.
In regards to a garnishment, you can make that request. I have not done a garnishment on fees, and so I would have to look at the law in regards to how the court would do that and if that's possible.
Okay.
Go ahead, Mr. McRae.
Thank you, Your Honor.
First of all, Your Honor, I'm going to do my best not to be redundant, but I do feel like there's a lot of overlap between these two motions, so my apologies in advance if any of this is repetitive, but want to be thorough. I'd like to, when we're talking about the issue of a stay, the first question is it's an injunction we're asking for, obviously. To that end, one of the key things we have to show here or on appeal is that we have a likelihood of success on the merits. And that's the reason why in the motion, Your Honor, I included so much factual background for what we're asking for. Mr. Zessin mentions that some of this involves relitigating. Well, that's, of course, necessary when we're dealing with the question of relief from a judgment. We have to try and lay the groundwork for the fact that there are, on the one hand, new facts, and on the other hand, old facts indicating injustice that need to be re-examined. I mean, it's inevitable that that's going to be part of the process. So to that end, I'd like to start just with a simple question, Your Honor. What if the report is wrong from October of last year? What if it's wrong? We've submitted some evidence that indicates that that may be the case. And it's not pie in the sky, Your Honor. It's very concrete. The analyses, there were very specific evaluations made by a very reputable engineering firm that cast doubt on all of this, Your Honor, all of it. The fundamental premises of that order, we submit to you respectfully, are flawed. That is a huge part of the reason why we're fighting so much, because we don't believe, Your Honor, that that fix is ever going to deal with this problem. There's a historic problem that Mr. Bexford himself acknowledged exists between these two parcels. It's a low-lying land area we have today, Your Honor, with us, and I'm not sure how to handle it in questions of evidence, but we have 9 affidavits from neighbors all the way around attesting to the fact that there is historical flooding on Mr. Brunger's property. If we have an evidentiary hearing on these questions, we look forward to that, because we don't have any problem proving anything that we're saying today. Walking backwards, Your Honor, in October of 2012, you signed this order, and it was thought to be, in the words of Mr. Bexford, a very shallow series of excavations, very minor in nature. And I believe Your Honor has reflected that that is still the case, at least in your estimation today, because we're not talking about, and Mr. Zessin acknowledges this, we're not talking about thousands and thousands and thousands of dollars worth of fixes, at least according to the analysis that we have. Whether or not that's actually going to fix the problem, a shallow incursion, we submit is an open question. October 2012, the order is signed. Mr. Bexford goes out, he surveys the property, he writes the analysis that we all are familiar with by now, and then he goes out and he gives specific instructions to Mr. Robbins on how to comply with what was in his report. I think it's universally acknowledged, Your Honor, that there were only these 2 visits to the land. The second visit was nowhere written down any specific instructions, nothing was codified apart from what was already in the existing plan. Mr. Robbins was given very specific instructions that day. And, Your Honor, I don't want to cause any objections or stirs or anything, but I have a site plan that I can indicate the different things that have happened historically throughout this. Would that be all right if it's a big thing, a big map of the site? Okay. Steve, can I have you?
So my expert can't testify, but his expert's drawings can be submitted.
This is not a drawing of an expert, Your Honor. This is pulled from the county's website. And furthermore, I believe this
offer
is...
of proof, and you made offer of proof in regards to evidence in your arguments too. So, I mean, it's an offer of proof. The court isn't taking it as evidence.
Okay.
Your Honor, when Mr. Bexford went out that first day, you can see here, well, the lines aren't exactly great here, so let me... I know. Well, you can't really see them well here either. But you have, this is the Brunger property here. This is the Orphan property here. This is admittedly before the pond was dug. The property line comes all the way back here. They're perfectly rectangular parcels, Your Honor, adjacent to each other. The swale that was instructed to Mr. Robbins to build in October 2012 ran about 100 and some odd feet from here, approximately here. It approximated the property line between the 2 parcels. And it was supposed to be 12 inches wide and 6 inches deep, and it was supposed to connect up the drainage that was allegedly available here in the blueberry farms down on the side. Now, we go forward, within a day of receiving these instructions, Mr. Robbins digs the swale, as he was instructed to do. He was never given any indication that this was a temporary fix. I know we've been through this, but to reestablish the factual basis for what we believe is a meritorious request for relief from the judgment, we have to go through this. Within a day, he had it dug. There was never any indication that this was going to be a temporary fix. There were 4 witnesses there, Your Honor, 4 that heard this these instructions. There was no mention of anything temporary. All it was instructed was this initial, relatively modest incursion, which is what the understanding had always been, and that was a key piece of the reason why he agreed to this rule to this order in the first place. If you're a tenant on a property, on a parcel, and someone tells you, okay, you have to dig a 100-foot trench that's 12 inches deep, 12 inches wide, 6 inches deep, that's not a major incursion. But when suddenly that becomes longer and you start talking about it has to run the entire length of the property and there has to be a drop-off and all this, now we're talking about altering permanent features of the land, and it becomes necessary, if it wasn't before, to join the owner of the property. But all that aside, Your Honor, in October, Mr. Robbins did as he was instructed, as 4 witnesses heard that he was instructed to do, and he dug the trench. He called Mr. Bexford once, he called him twice, he called him 3 times, he called him 4 times. He emailed him, Your Honor. We can prove all this. We have phone records, we have the email. There was no response, none, for 8 months until there was flooding in the spring.
A hearing on this.
I'm sorry, Your
I
Honor?
remember the hearing on this. Mr. Robbins testified at the hearing about this. Mr. Bexford acknowledged he didn't talk to him for a period of time. It's not significant to the court.
Be that as it may, Your Honor, with all due respect, if Mr. Bexford, up or down, would have said this is good, this is not good, if he would have responded to Mr. Robbins' request to tell him whether he'd done what he needed to do or not, we wouldn't be here today. We simply would not be here today. 8 months go by, spring rains come, you get 7 inches of rain over a night, Mr. Brunger gets upset because, lo and behold, the trench doesn't fix the problem. And then we're back here right again, away. The first contact that Mr. Robbins had with Mr. Bexford was 7 months later, Your Honor. He tried to call him again because he got hit with contempt. He's like, why am I in contempt? I thought I did what you told me. Mr. Bexford said, well, if the ditch is fine with you guys, it's fine with me. According to testimony that's already been put on the record, I believe, Your Honor. I don't want to misquote. And Mr. Zesson, I'm sure, will correct me if I'm wrong about that. But then Mr. Brunger starts calling Mr. Bexford multiple times saying this didn't fix the problem. Mr. Bexford goes to the property uninvited, unannounced, shows up walking on Mr. Ortman's property, staking it again, 100 feet longer than had been indicated the prior time. And at this point, we got involved, Your Honor. And the first thing we did was bring to the court's attention, now that we're talking about bigger excavations, we're talking about dominion and control, we need the landowner joined. And that's why we made such a fuss about this at the time.
No, it came to the court's attention because Mr. Zesson filed a motion for contempt because it wasn't done.
Well, what I mean, Your Honor, is as soon as we found out about the issue of ownership, we brought it up in all the pleadings that we filed in the early summer and midsummer of this year.
You didn't know your own client didn't own the property?
I'm sorry, Your Honor?
You didn't know your own client didn't own the property?
No, we found that out immediately, Your Honor. We were hired, I believe, in May. Is that right? Yeah, and I think in June or July we filed these motions that we're now talking about staying the effect of the judgments on. But regardless, had Mr. Bexford gotten back to Mr. Robbins, Your Honor, the order called for him to verify that there had been compliance. There was no effort of verifying anything until there was a further flooding problem in the spring. So this is why you asked earlier, why are we still fighting about this? Why are we dragging it out? Because from our perspective, Your Honor, and we feel like this is important, Mr. Robbins has attempted to comply. And as soon as it was clear that there were going to be major excavations, Mr. Ortman got involved and said, no, it's my land. I'm going to deal with big excavations. You're out of this. Which I think is entirely a logical proposition if you're the landowner. And he attempts to comply, and now that's not sufficient either. Now, Your Honor, we can also, Mr. Alvarez alluded to some of this. The Holland Engineering report that I submitted as Exhibit I to my motion for a stay casts significant doubt on the original report altogether. There's not a site that when they went to the property to do analysis, there was no site benchmark that had been left for them to tie into to be able to determine what the elevations were that Mr. Bexford was utilizing. They therefore used the two structures, the elevations of those two structures, but one of the structures, I believe, was indicated to be 640 feet of elevation, while one of them was 750. So, and the 640 number is important because the report that Mr. Bexford gave to the court, telling how the swale had to be built, said that it had to give historic relief at 639.1 feet. Now, if the 640 number is wrong, therefore the 639.1 number is probably wrong too, and the whole thing goes up in smoke at that point, Your Honor. This is what we're trying to say. This is why we believe there should be relief from this judgment. Beyond that, there is they certified, Holland Engineering did, that the swale that has been constructed now by Mr. Ortman complies with the initial report because it's providing an extra foot of elevation of swale drainage as opposed to what the original report ordered in the first place. There is a grade that runs about, I think it's about roughly a foot from the top of the property from the north to the south, and presumably this is sufficient to affect the drainage, given that it's a foot lower or so, I believe, if I'm quoting the report right, Your Honor, which is at Exhibit J. I think he actually addresses it in Exhibit I and Exhibit J. But we have a swale. It's been certified by one engineering company, not by the person who initially authored it, that has given different instructions now and has made bad measurements. Furthermore, Your Honor, at the point in time when we signed, well, when Mr. Robbins signed this order, a key piece of the equation as well was that Mr. Bexford was an independent source, an independent expert that would address all this from a neutral perspective. And I think, as I understand this, and again, I anticipate Mr. Zessen correcting me here, that Mr. Bexford was working for free, at least at first, or he was trying to do this as just to resolve the problem easily. Now, if the impartiality of the engineer is called into question, which we believe it has been now because he didn't respond to Mr. Robbins' phone calls for trying in good faith to comply with the court's order, he does respond to Mr. Brunger, and he shows up unannounced on the property, and he restakes it, and he adds to the length. This indicates that we don't have somebody who's and I believe also he's been now paid by Mr. Brunger. We think, Your Honor, that there should be an evidentiary hearing on this question of whether the swale will actually fix this problem altogether. We think it's a key piece of finally solving this problem once and for all at the end of the day, which is why we made the objection that we did earlier. At some point, we anticipate Mr. Bexford is going to have to testify, but we would like to be able to check his facts against another engineer's report. Mr. Alvarez also alluded to the fact that there's a berm on Mr. Brunger's property, that maybe Holland Engineering identifies this just based on their site observations, that could be contributing to this ponding effect. And also, Your Honor, I'd like to just point out for the record that this whole thing started because of the excavation of the pond. If the fear is that the pond is going to overflow its banks and then flood Mr. Brunger's property, that indicates that there's a flow direction from, I guess it would be east to west, not south to west. Now, this gets complicated in terms of engineering. I can't speak to it. I'm not a topographical expert. But that's why we submit that these questions are important. If the idea is that we want to keep drainage from the pond, or we want flooding from the pond to not go over the border, then we're going to have to address the question of, well, okay, is a relief swale really that's down there in the southwest, or excuse me, in the south corner? It's not going to affect anything if the flow direction is in the middle of the property across from east to west. I'm going to be getting that backwards. But also, Your Honor, for the record, Mr. Ortman has, and we have photographs we can show of this, also constructed a pipe that runs from the corner of his pond all the way to the lower southwest corner as well, affecting drainage. So not only has he tried to build the swale in accordance with the instructions of Mr. Bexford, but he has also installed a pipe now to try and deal with this issue of potential flooding as well. The essential problem, Your Honor, in all of this is that the goalposts have been moved. This is the essential problem that we have with this entire thing. We don't want the goalposts to keep getting moved. When this problem resurfaces in a year, which we submit is a very likely possibility, after complying with what Mr. Bexford is now indicating would be a solution, we're going to be right back here again, Your Honor. We could solve this whole thing right now. We just have to get to the bottom through discovery of what's actually going on. We think that mandates relief from the order of October of 2012, and allow Mr. Robbins to join this suit properly, and to file answers and defenses, and to go through the discovery process and figure out what exactly is going on here. Because yes, you're right, Your Honor, there is an order. That order was predicated on certain things that we submit have been called into question by all of this. Thank you, Your Honor, for your time, and if you have any questions, I'll be happy to answer.
Thank you. Mr. Dusty?
Your Honor, I have submitted a response to the motion filed by Mr. Robbins' counsel requesting a stay of proceedings. The court rule that's relevant here is MCR 7.209. And 7.209 sets forth very specific requirements of what needs to happen in order for a stay of proceedings to be entered. The actual title to the Michigan rule is bond, stay of proceedings. The first part of this section, which is the only relevant section for your consideration today, says that, first of all, the appeal does not automatically stay any of the enforcement of your order. So we start from the proposition in paragraph A that your orders are enforceable unless you find some reason why they should not be enforced in the stay proceedings. The next part of this, paragraph B, talks about the responsibility of setting the amount of bond by the trial court. And in civil cases, the dollar amount of the stay of appeal in a civil action must be set by the trial court in an amount adequate to protect Mr. Brunger. That's paragraph B of 7209. And the amount that has to be paid as a bond, according to Sun Valley Food Company versus Ward 221 Mishap 335, which is a 1997 case, says that the purpose of an appeal bond generally is to protect the prevailing party, Mr. Brunger, from losses that could result from the inability to enforce the judgment during the stay pending appeal. That's the first hurdle that we need to clear. What are the damages that Mr. Brunger is going to incur if you stay enforcement of the order? Now, what we have factually is we have a berm that's partially, we have a swale that's partially dug, and that needs a little more excavation to be completed. And once the little more excavation, which Mr. Bexford would testify is 3 or 4 hours of further excavation, would provide the relief that he's said would be appropriate, which the parties agreed would be appropriate. So what we're talking about is a real narrow issue. That is, do we complete the 3 or 4 hours of excavation that needs to be done in order for the water to be evacuated off of Mr. Brunger's property? Or do we wait 12 to 18 months while we kick this down the road to the Court of Appeals and let them decide whether there's any merit to their appeal? Okay? So I didn't hear counsel talk about what is the harm in completing the swale that they began. They stand before you and argue that there is something wrong with the idea that we would put a swale out there. Now that we've had time to think about it since October, we wish we would have hired an expert. We wish we hadn't agreed with Mr. Bexford because he's all wrong. Now, the report that they agreed to all the way through these proceedings now suddenly is not wrong. Yet, even though it's wrong, they still go out and construct the swale after the August 26th hearing. So we've got this swale that's mostly completed, needs a little bit more work for the last 100 feet. 5.5 inches of dirt needs to be taken off of a 12-foot wide piece of property, 100 feet long. That's what's left to be done in Mr. Bexford's estimation to complete this. What is the harm in taking the rest of the dirt off, as opposed to what is the harm in not taking the dirt off, leaving the swale constructed wrongly, and allowing the water to continue to accumulate? Those are the two facts that you need to balance. Okay? Are we going to subject Mr. and Mrs. Brunger to further continuing harm, further lack of use of their property, further flooding on their property, further subdivision of their pole barn, which sits out in this area where the water is backing up? which is going to cause who knows what kind of damage prospectively if we allow this to continue, and the continuing attorney fees and the continuing engineering fees. These are the damages that Mr. and Mrs. Brunger are going to continue to experience. This is injunctive relief. This is irreparable harm that the court found would exist by stipulation, and they agreed, and you agreed, that this is irreparable harm. Injunctive order is appropriate. If we have harm that is irreparable, why do we want to continue it for another 18 months while the Court of Appeals makes their decision? Weigh that with what is the harm in completing the swale with what is the harm in not completing the swale. What kind of a bond is the court going to set in order to ensure that the damages that Mr. and Mrs. Brunger will continue to incur is appropriate and adequate to protect them if your orders are upheld by the Court of Appeals and the Michigan Supreme Court, which I am very confident they will be in light of the fact that they are consent orders. And they're based upon a party coming into court with counsel, having the opportunity to review information that's been provided to them, having an opportunity to do their own engineering studies at the time if they didn't, foregoing that opportunity, and then accepting by way of a written stipulated consent order to the court that we will abate the nuisance that we created by going through these steps. I don't think there's much of a chance that a consent order of that design is going to be overturned by the Court of Appeals because suddenly they come up with a theory that some other relief is appropriate. I haven't heard. There's been no offer of proof what other relief is going to be appropriate to abate the nuisance. There's no constructive plan in place that they would propose that says this is what we ought to do instead. They just say, we don't like the one that you have. So paragraph B of 7209 says, in civil cases, you need to set a bond, the court needs to set a bond that will protect the prevailing party from losses that could result from the inability to enforce the order, which is only the inability to complete 3 or 4 hours more of construction in a swale that they agree they did in an attempt to comply with the court's order. Once you decide what bond is appropriate, then the court has to look at paragraph or MCR 7.209E, which sets forth the standards by which the trial court may issue a stay of proceedings pending appeal. And subparagraph 1 simply states that the trial court may order a stay of proceedings with or without bond as justice requires. Subpart B states that when a stay is sought after an appeal is filed, which has happened in this case, they filed the appeal first, and now they're seeking a stay of the proceedings, any bond must meet the requirements set forth in subrule 7.209F. If we look at 7.209F, that provision of the court rule requires the court to find in civil actions that the appellant promises in writing, number 1, to prosecute the appeal to decision, number 2, to perform or satisfy a judgment or order of the Court of Appeals or the Supreme Court, paragraph C, to perform or satisfy the judgment or order appealed from if the appeal is dismissed, D, which he's never going to do, D, in an action involving the possession of land or judgment for foreclosure or mortgage or land contract to pay the appellee the damages which may result from the stay of proceedings, and E, to do any other act which is expressly required by statute authorizing the appeal. The significance of these promises in writing to the court is that when Mr. Robbins appeals the case, he accepts certain responsibilities. That's why the court rule requires these promises to be in writing. Nowhere in the motion for stay of appeal and nowhere in the appeal itself does Mr. Robbins or his counsel attempt to comply with the requirements set forth in MCR 7.209F. 7.209E doesn't say that he may. It doesn't say that he can do some of them or part of them. It says he must. The court must require those things. He's not done those. And therefore, his request for stay of proceedings has to be denied because he has not complied with the requirements of the court rule. So the relief I've requested is, first of all, that you obviously deny the appeal or the stay pending appeal. And secondly, that if you're not going to do that, then you have to order a bond for Mr. Robbins to pay into court to satisfy all the obligations that Mr. and Mrs. Brunger financially may incur as a result of staying the proceeding of this case.
Do you have a amount that you would proffer as far as what that bond would be?
Well, again, there's $6,000 ordered already in attorney fees. I expect that that will go to about somewhere around $10,000 with engineering fees and studies and time that I have to take to prosecute the appeal. We still have the loss of use of the property, and we have the damages that could potentially occur to the foundation of this building if the water is not evacuated properly. And once we start replacing foundations and cement and buildings, then I think the amount of damages proliferate, but I would request specifically a bond of $10,000 in addition to making Mr. Robbins pay the $6,000 that's already been ordered. So if I'm saying there's $10,000 in addition to the $6,000, so that leaves you with $16,000.
Thank you.
Your Honor, I know you have something scheduled at 3:30, so if I could just respond briefly to this business about the statute.
I did not say you had to stop, did I?
Oh, no, of course not, Your Honor. Again, I'm going off of my conversation yesterday. Just want to respect the court. First of all, Your Honor, from the provisions that Mr. Zessin recited in detail to you, I think you heard quite clearly that in subsection E of 7.209, it says, except as otherwise provided by law or rule, the trial court may order a stay of proceedings with or without a bond, as justice requires. That is the key provision for all of these questions about whether we complied with 7.209F and all of this. There's no 7.209F says, Your Honor, if in a bond filed for stay pending appeal in a civil action, then it goes on and it lists the requirements. Well, if you don't order a bond, then there's no need for us to comply yet with 7.209F. The moment you order a bond, we will address that question however we see fit strategically, and we will comply with 7.209F. As of now, that's a premature question because we haven't gotten there yet. If you decide to order a bond, Your Honor, we will, of course, comply with that subsection. So I don't see that. I think that's a non-issue at this point. That's premature. But beyond that, Your Honor, I also cited the fact that you can decide to order a bond or not, and Mr. Zessin rightly brings up the question of the balancing of harm in this case. He holds out, he refers to the order of October 2012 as indicating that there's irreparable injury somehow, that proves that there would be irreparable injury to the property. That simply is not what the order of October 2012 does. It's a judicial acknowledgement of a stipulation to solve a problem. That in and of itself isn't even necessarily an indication of guilt or liability. Yeah, in some degree, Mr. Robbins tried to take responsibility for what was agreed to, but that by itself doesn't establish irreparable injury of any kind. Now, having said that, going on, it would be stupid of me to stand here before this court and try to tell you that the potential flooding is irrelevant and that it's a non-issue. Of course, it's important. We're trying to get to the bottom of why it's actually happening, Your Honor, and we're trying to provide evidence to this court that maybe it's not Mr. Robbins or Mr. Ortman's fault. That we've tried to do that to a blue in the face, and I hope that at least our earnestness is worth something. But beyond that, Your Honor, you weigh against this flooding, which Mr. Bexford in his initial report acknowledged is a permanent condition of these low-lying lands, which has been going on for a long time. You weigh that against Mr. Ortman being his land being significantly excavated upon without him still being subject to any injunctive order of any kind. His case may be consolidated with this one, but there's still no injunction issued by this court that affects him. So in essence, what's being ordered is the excavation of his land without him being party to the case. That's significant harm, Your Honor. We submit that could constitute a taking. We don't know yet, we haven't researched that issue, but that's significant potential harm, especially if he's not responsible, and we can ultimately prove that. Beyond that, the fact that Mr. Robbins has been ordered to pay all these fees, these attorney's fees, and now to pay for the engineer as well, even after I tried to recite, Your Honor, these continued efforts of him and Mr. Ortman to try and fix this problem in good faith. He did stipulate to this order. He did do the work. No one denies that in October of 2012. He tried to comply, and I don't think Mr. Zesson will deny that he tried to get in touch with Mr. Bexford about it. And then he participated in this. He was represented by counsel. Mr. Zesson is absolutely right, but he has at every point in this proceeding, Your Honor, contrary to what's asserted here, exercised good faith in trying to participate. At this point now, when we're talking about serious excavations, yes, Mr. Ortman is now, we think, rightly supposed to be joined as a necessary party, but he's going to face the prospect of $10,000 or more in attorney's fees and costs for something for which he has tried to comply time and time again. He undertook strenuous efforts to get in touch and to have verified whether he was in compliance or not, based on what he did in October of 2012. When all of a sudden there was flooding again in the spring, which we think there will be, even if the swale gets entered, Your Honor, if it gets dug, there's still going to be flooding. And if that happens next year, where are we going to be? So we submit that Mr. Robbins' initial earnest attempts to try and comply with these orders and his constant good faith being punished with attorney's fees, engineering fees, costs, etc., in excess of $10,000. He and his wife are a middle-class family, Your Honor. They do not have $10,000 just laying around. They're going to have to they may have to contemplate the possibility of bankruptcy. And for that matter, there's the issue of excavating on the land of a party who's not joined yet. We submit that these are significant harms that would accrue to the defendant in this case, and potentially to Mr. Ortman, although that's not necessarily, it's jurisdictionally questionable how I get to that point, but the bottom line is that would be the effect of not staying this judgment, would be conducting excavation of land of a party who's not, significant excavation of land of a party who's not joined yet. Thank you, Your Honor.
Is it not true that Mr. Ortman's been present at all the hearings in this case, even though he was not a party?
It's my understanding, Your Honor, that he's been present at most of them, all of them.
The last one I was sick.
Oh, that's right. If that's correct, Your Honor, except the last one. What were you sick with, Brian?
Well, I had
It doesn't matter. We do have a letter from his. We do have a letter from his
Because
doctor. Your Honor.
the fact that he was here for the previous ones is of more concern to the court than... My recollection of Mr. Robbins' testimony on July 23rd of 2013 was that he knew he was violating the court order, and he went and violated it anyway. That's my recollection. And I remember being very concerned about that. Because it appeared that he knew what the order was, and his intent was to disobey the order. The court is looking at that hearing right now. I don't have a transcript of it, and although I take notes on files, I don't have the notes in front of me right now.
Your Honor, it was my recollection.
I'm doing something. Thank you.
said in October. And he thought he removed the stakes in May. No, because he had no rights to be on the property at that point. Okay, so because he didn't have a right to be on the property, then he had a right to ignore what his direction was. He had no business on the property in May. It was done in October. He ignored his instructions that he placed on the stakes on your property in May of 2013. You ignored them. No, I took the stakes out because he wasn't supposed to be on the property. He had no rights. He's been trespassed at this point. Do what Mr. Baxter directed you to do and exercise on stakes. Objection asked and answered. Well, it's been asked. It hasn't been answered. I did what I was told to do in October by Mr. Baxter. I have witnesses that will testify to this. Let's answer a different question than I'm asking. I understand, and I think that I'll just testify. Okay, nothing further on it. Mr. Evans, in April, you had a conversation with Mr. Baxter about the danger of the fight.
You have something else you want to say, Mr. Alvarez?
Oh, no, Your Honor. The audio speaks for itself.
Well, I think it's pretty clear that it's up to, it's my discretion as to whether or not I grant a stay. And then if I do grant it, it's also my discretion as to whether or not a bond is ordered. The irreparable harm that defendant raises is the harm to Mr. Ortman's property, which has already been, from what the court understands, disrupted by Mr. Ortman and Mr. Robbins. And then, in fact, the property that's involved is, in essence, the issue is to complete the process of a properly constructed swale, because there's already been a ditch dug that does not meet the definition of a swale, and that if the swale was properly constructed in the place where the ditch is, which the defendants have already altered the property, that there would be a resolution of the issue before the court, which is whether or not the agreement between defendant Robbins and the plaintiff has been met. There has been a lot of side issues presented to the court regarding other property issues and other property concerns, and whether or not there is additional reasons as to why this property may have flooding on it. The understanding the courts had from the onset of this case is that whatever the water issues are in regards to the property, that they became worse, and the pooling became worse after Mr. Robbins and or Mr. Ortman changed their property by changing creating another area or removing dirt, can't remember exactly what they did, that resulted in a change in what was occurring on the plaintiff's property. And that I'm not sure that it's ever been stated, I don't recall hearing this, that Mr. Brunger ever had problems, never had any problems with flooding on his property. Having lived in Lake Township at one period of time in 2009, I believe it was, when we got 10 inches of rain in one night, sure, everybody got flooded, and you couldn't blame that on what your neighbor did. I'm not saying that I don't think that was ever averred, that this issue in regards to the increase of a problem on Mr. Brunger's property would result that he would never have any problems with his property again. What he wanted was to get it back to where it was before the change was done by the defendant or defendants at this point in time. So this discussion about a lot of peripheral items in regards to the property problems may or may not be true. I don't know. I don't know that it matters, because I don't think that's the issue before the court. The issue before the court was the property was this way. The defendant or defendants changed their property, which resulted in a change in the plaintiff's property, which is why there was a lawsuit brought to begin with. Not that there's a problem with the plaintiff's property and the defendant has to fix all the problems on the defendant's property. No, there was a change, and to a certain extent an acknowledged change, because the defendant, Robbins, agreed to do something to rectify what had already happened on the property, his property, that resulted in harm to Mr. Brunger's property. So I don't know what irreparable harm there is to the property that the court considers to be the Robbins-Ortman property at this point in time. Mr. Robbins obviously had control of it, and Mr. Ortman, I don't think there's any debate, owns it. I don't understand what the irreparable harm is to their property, since they've already dug a ditch. And all we're trying to do is refine the ditch into a swale. That's how the court views it. That's what I've been hearing. And I've not heard anything to say that turning this ditch into a swale, which would result in a few hours of work, is somehow or another going to cause irreparable harm to Mr. Ortman. I can't even conceive how that would happen. Now, is Mr. Brunger going to have water problems after this swale is constructed? I don't know. But if he does, the court would kind of believe at this point it's not Mr. Robbins' problem at that point. There may be another problem. There may be something else that has to happen. I don't know. But it solves the problem of this particular case on a very narrow issue. We're making up these broad issues come into this court that I think is too far afield of what we're really supposed to be focused on here. It doesn't appear to the court that any harm to the defendant outweighs the harm to the plaintiffs. I don't know if Mr. Berger's going to have more flooding after we dig this swale, but I do know that if that swale is done properly, according to what Mr. Beckford said it was supposed to be done, that complies with the court order, and that part is done. We don't have to worry about that anymore, because it's done. We agreed to it, we do it, it's done. Mr. Brunger has flooding on his property. You can't blame it on the swale or the ditch or anything else, because it's done. I did what I wanted you to do, what needed to be done. Okay, let's move on. I got some other water problem on my property. Can't blame it on the swale anymore, the ditch. It's not a swale. I don't think there's any doubt that Mr. Robbins was in control of the property. He acted as if he controlled the property. And the law clearly states that if the owner or the person who controls the property can be held responsible. I don't think there's any doubt about that. At this point in time, I don't believe it's appropriate to stay this case. We need to get this work done. That's the order of the court.
Is there a time frame, Your Honor, to complete this work, since it's been an issue?
I think it should be completed before we get into frozen ground, and it can't be completed.
That's why I'm asking the question. Our excavator that you've ordered to be on the property with 7 days, can be out there to finish the work.
14 days.
14 days?
Thank you.
Thank you, Your Honor.
Adjourned.